Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Hello and welcome to SCOTUScast. I'm your host, Justin Drewer, on behalf of the Faculty Division of the Federalist Society. We're here today to discuss Yegiazaryan v. Smagin, which was argued before the court on April 25th. It's my honor to introduce our guest today, Professor Aaron Simowitz. He is an associate professor at Willamette University College of Law, where he teaches civil procedure, bankruptcy, negotiation, and a seminar on negotiating and drafting a complex transaction. His research focuses on cross-border business transactions, litigation, and arbitration. He is a chair emeritus of the AALS section on conflict of laws, the director of the Business Lawyering Institute at Willamette University, and an affiliated scholar with the Classical Liberal Institute at New York University. And we're very happy to have him join us on SCOTUScast today. So thank you for joining us on a kind of an early morning time on the West Coast.
Thanks so much, Justin. I really appreciate it. I'm delighted to talk about this case.
All right, so starting us off, can we talk briefly about the background of the case and how it got to the Supreme Court, and also a brief comment on why our audience should care about it to continue listening?
Yeah, absolutely, Justin. And I'll actually start with the last question first and sort of zoom out and talk a little bit about why we should care about this case before we get into the guts of the case. So what's really at stake here is what types of transnational disputes will be heard in US courts. And when I say transnational disputes, what I mean are disputes that take place between two private parties, but kind of cross sovereign boundaries. Like there's some stuff that's happening in the United States, and there's some stuff happening abroad. And there's always these questions about sort of how much US stuff there has to be in this case in order for it to come into US courts. And really, over the past 15, 20 years, the court has pretty consistently been skeptical of allowing these transnational cases to proceed in US courts. And there are a lot of different levers the court can and has pressed on to get these cases out of US courts. You know, there's personal jurisdiction, which the court has narrowed a lot over the last sort of decade plus. There are doctrines like forum nonconvenience. There are doctrines of immunity. There are doctrines of international comedy, and we're going to talk about today in the Smagin case, there are doctrines of choice of law. To some extent, with almost all of those areas, the court has narrowed them, has curtailed them in such a way that makes it harder for plaintiffs to bring these transnational cases in US courts. My colleague Pamela Bookman calls this litigation isolationism. And I think for a long time, the sort of unstated assumption was that, you know, because here we have class actions, here we have broad discovery, here we have contingency fee systems, that if a case couldn't be brought in US court, it really couldn't be brought anywhere. So if the court said, you know, this isn't the right place for this case, that would actually be the end of the case. That's much less true today than it was even 10, 15, 20 years ago. What we're seeing now is, if a US court says, you know what, you've got this transnational case, maybe it's against a big corporate multinational, you can't bring this in a US court, that case is going to proceed in another country's courts, right? And the defendant, which might be a US-based defendant, might not be happy with that result. And so as we're seeing this shift from a world in which these big transnational cases proceed in the US or not at all, to a world where, well, look, these transnational cases can go forward here, or they can go forward elsewhere. That raises this really interesting question about, will the court's perspective on these cases change? Will the court start to look at these transnational cases and think, you know what, it doesn't actually serve the interests of the United States as a nation, doesn't really serve the interests of the US judiciary, doesn't really serve the interests of US parties to be moving so many of these cases out of US courts. So that's the sort of big picture why you should care, what's going on in this case in the broadest strokes. Okay, now to get into the guts of this case a little bit more. This case concerns the last of those sort of doctrinal levers that I mentioned, which is choice of law. When will US law apply to govern a dispute that takes place sort of in part abroad and in part here? And this case deals with a particular type of choice of law, which we sometimes call extraterritorial application of US law. Sometimes we call that prescriptive jurisdiction. Just a way of saying, does Congress have the power to prescribe the rules, prescribe the law that will govern what happened in this case, or did Congress prescribe rules that govern a case like this that has some elements here and some abroad? And part of what's going on here is that the Supreme Court really changed the way we look at these questions in a 2010 case called Morrison v. National Australia Bank. It was an opinion by Justice Scalia. He took the sort of way courts had been answering this question, will US law apply extraterritorially? The way US courts have been doing that for about 60 years, and really changed it. He sort of created or revived or reinvigorated something called the presumption against extraterritoriality. And that was a securities case where you had the alleged fraudulent conduct was in Florida, but the securities were traded on an Australian exchange. And the court had to figure out, is US securities law going to govern this question? And the court, Justice Scalia writing, said, this is a two-step inquiry. Step one, we have to ask, is the presumption against extraterritoriality rebutted? Which is to say, we have to ask, is there a clear indication in the statute that Congress enacted it to cover conduct that occurs abroad or cover other things that occur abroad? And sometimes Congress does that, right? Sometimes it enacts statutes about international human trafficking or international terrorism, right? That clearly is designed to govern stuff all over the world. And Justice Scalia says, look, at step one, if the presumption is rebutted, you're done. US law will cover this dispute, even if there's stuff happening outside the country. But if you can't rebut the presumption, if there's not that clear indication, then you go to step two. And step two is, okay, this statute doesn't apply extraterritorially. Does this case present a domestic application of the statute? That's a surprisingly hard question, right? And what Justice Scalia said is, we have to look for the focus of the statute, which he said is the object of the statute's solicitude, and then determine, in this case, is the object of the statute solicitude in this country or is it outside the country? And you'll recall that I mentioned in the Morrison case that the alleged fraud took place in Florida, but the securities were sold in Australia. And so there was this argument about, is the focus of the Securities Exchange Act the fraudulent conduct or the securities transaction? And Justice Scalia said, writing for the court, the object of the statute solicitude, right, the Securities Exchange Act, is the transaction. In this case, the transaction is abroad. Therefore, in this case, this is not a domestic application of the statute. US law does not apply. Right? Now, a lot of us wrote at the time that this second part of the test was going to be a lot harder than the court was letting on. And that has turned out to be the case. And so what we're seeing in this case, Yegiazaryan v. Smagin, is kind of the downstream questions raised by that Morrison decision. And this is not actually the first time the court has interpreted the statute, the presumption against extraterritoriality for the statute issue in this case, which is the Racketeering, Influence, and Corrupt Organization Act. The court saw this in 2016 in a case called RJR Nabisco v. European Community, where it said, yeah, this statute, step one, the presumption is rebutted sometimes, but for private plaintiffs, there's another section of the statute, 1964C, and that section of the statute, and I'll read it to you because the text becomes important. Any person injured in his business or property by reason of a violation of section 1962 of this chapter may sue, therefore, in the appropriate United States District Court and shall recover threefold damages. The court said that provision, which is the provision that lets private persons sue, it creates the private cause of action, does not rebut the presumption against extraterritoriality, so it flunks step one. And on step two, the focus of the statute is the injury, which means that if a private person wants to bring a claim under RICO, they have to allege a domestic injury in order for this to constitute a domestic application of the statute. And there it was the European community bringing the claim. They had conceded that their injury was in the European community, and so US law did not apply, right? I raise all of this in part to do sort of table setting, so we can understand what's going on in the Smagin case, which is the latest iteration of this, but to also kind of emphasize the Morrison case sort of kicked up enough dust, it muddied the water, that it wasn't enough for the court to come back and apply the Morrison test to this statute, RICO, in RJR. Now they've had to come back and revisit it again in Smagin to deal with the questions raised by the Morrison case. Okay, with all that table setting, let me tell you a little bit about this case, Yegiazaryan v. Smagin. This case involves two Russians and a bank. We've got one Russian, Smagin, who lives in Russia. We've got another Russian national, Yegiazaryan, who lives in Beverly Hills in California. And we've got a bank in Monaco, CMB Monaco. And in fact, this case, and this becomes important, is consolidated with the case CMB Monaco v. Smagin. So what happened here? Smagin and Yegiazaryan, they had a dispute. And Smagin obtained a very sizable London arbitral award against Yegiazaryan. Now, Yegiazaryan, as is often the case, did not just write him a check to cover the amount of the arbitral award. And so not having received any funds, Smagin took his arbitral award to California, where Yegiazaryan is domiciled. And as he's entitled to do under the relevant international treaty, said to the California courts, hey, California courts, take my London arbitral award and convert it into a California judgment. So I can use all the powers of California courts to compel Yegiazaryan to pay the money that this award says that he owes me. Smagin then says, he alleges that what Yegiazaryan does is he engages in a conspiracy with some of his family members and this Monaco-based bank, CMB Monaco, basically to hide, secrete, dissipate assets, to avoid paying the arbitral award and the California judgment enforcing the award. And then Smagin's lawyers actually do something quite creative. They say, you know what? This group of folks who've gotten together to help Yegiazaryan evade paying Smagin, they're engaged in a conspiracy. And you know what? It's not just a conspiracy. It is a pattern of racketeering conduct. It is a racketeering enterprise, which Smagin alleges brings it within the ambit of the statute that I mentioned earlier, the Racketeering, Influence, and Corrupt Organization Act, or RICO. Now, RICO is a statute from the late 70s, which was really designed to combat the mob. But it was framed so broadly that it's been used for a lot of different stuff, including the litigation about corruption in FIFA from a few years ago. And RICO does a lot of things, but the two things that are most relevant here is that if a bunch of folks have gotten together and engaged in a racketeering conspiracy, RICO will actually make them all liable for that conduct. Right? RICO is very good at spreading liability around. The other thing that RICO does, and this shows up right in that section of the statute that I read you a moment ago, 18 USC 1964C, is it provides treble damages. You take whatever harm you suffered, you multiply it by 3, which is really strong medicine and is a very rare remedy outside the United States. So Smagin brings this RICO action, not just against Yegiazaryan, but also members of his family and also against this bank, saying in effect, you know what, you conspired to not pay my $100 million judgments. Now, each of you is going to be liable to me for $300 million. This raises the question, teed up in Morrison and later in the subsequent case about RICO, RJR Nabisco v. European Community. Has Smagin alleged a domestic injury such that he is entitled to bring this action under US law under 18 USC 1964C? The particular property that he's alleged that was injured here is an intangible property, right? It's a judgment, right? Judgment doesn't exist in any one place, right? It's in the ether, not like a vase or a Lamborghini or a house. So if a judgment suffers injury, where does that injury occur, right? Has this injury occurred where Smagin felt the hit in his pocketbook in Russia? Or has this injury occurred, let's say in California, where the judgment is, where Yegiazaryan is, where allegedly he directed this enterprise to evade the judgment?
That is very interesting. I like his, if nothing else, I like his team's spirit there, trying to get everyone for all they're worth. But transitioning to the oral argument, are there any surprises or key takeaways that are worth touching on in the argument? Any convincing case made by either side or both sides that we should talk about?
Yeah, let me get in a little bit to the arguments made by each side. And I should say, Justin, to your point, look, I was a creditor's rights lawyer at Gibson Dunn before I was an academic. So it was my job to, find folks who didn't want to pay their judgments or their awards and search the world for assets, find them, seize them, and sell them. So, I'm delighted when somebody comes up with a creative way to get judgments enforced, although, you'll find I'm somewhat critical of Smagin's legal arguments at the end of the day. But yes, I agree with you. So the arguments for each side. Yegiazaryan's counsel makes two arguments. The first is really a statutory textualist argument. Right? Go back to the language of that statute one more time. Any person injured in his business or property by reason of a violation of 1962C of this chapter may sue therefore in any appropriate United States district court. Yegiazaryan's counsel says, look, the statute says any person injured in his business or property. So we're talking about injury to a person, not injury to the business or to the property. And so Yegiazaryan's counsel says, look, because of the language of the statute, any person injured in his business or property, we don't look behind the person at all. We look to where the person is who suffered, and that's it. Here, the person who suffered an injury, whose pocketbook was hurt, right, who doesn't have the $100 million that he would spend on whatever he wants to spend it on, is Smagin. Smagin is in Russia. That's where the injury is. There's no domestic injury here. This is not a domestic application of the RICO statute, full stop. And, that might seem like a sort of slender reed to hang this whole case on, to say, look, a person injured in his business or property is really different from an injury to a business or property. But, full credit to Yegiazaryan's counsel, they found this wonderful 1906 opinion by Justice Holmes called Chattanooga Foundry and Pipeworks, which pretty much says exactly that. And indeed, that case, obviously RICO didn't exist at the time, but interpreted the similar provision in the antitrust statutes, which were the model for the private cause of action in the RICO statute. So there you've got Justice Holmes saying, look, where the statute says injury, any person injured in his business or property, we do not look behind the sufferer. We look to where the person is, full stop. So that's Yegiazaryan's first argument. That's the textualist, just the text argument. Now, Yegiazaryan's counsel says, look, if you don't buy our textualist argument, we have a second argument. If you're really going to look to where the property was injured, where that injury was felt, well, sort of conflict of laws rules that talk about where economic loss is felt says you should look to the domicile of the creditor, the owner of the property, right? Where is an injury to this California judgment felt? It's felt still where Mr. Smagin's pocketbook is. That's where the economic loss is. That's where the money that would be spent isn't now. So Yegiazaryan has two arguments. There's the textualist argument, and then there's the sort of argument that is, look, if we're talking about injury to this California judgment, that's actually felt where the creditor is, which in this case is Moscow. Smagin's argument, right? First of all, they reject that statutory argument. They said, yeah, this into distinction, it's not persuasive. They say, look, okay, we're talking about where a judgment is, where an injury to a judgment is felt. And they make a couple different arguments. They say, well, it could be that for a judgment, because a judgment is a debt, but it's a particular type of debt, right? A court has rendered it. You should really look to where the court is that rendered it. And their principal argument is when making this analysis, this sort of step 2 of the Morrison analysis, is this a domestic application of the statute? We should really focus on where the conduct is. And they say, here, Yegiazaryan, his conduct, he directed this racketeering enterprise from California. Therefore, we should look to California. That's where the injury was, because that's where the conduct was. So that's the sort of the terms of the debate on each side. Now, to your question about sort of, was there anything surprising? Was there anything surprising that came out of the oral argument? Well, I guess I should say what's not surprising is that pretty much every member of the court came to this looking for a bright line rule. This court does not like multi-factor balancing tests. And I think that's been true of the court for a long time. Indeed, that was a sort of driving factor in that Morrison case from 2010, that Justice Scalia opinion. He said, look, we don't want an approach that's going to require us to balance anew. We want a clear, bright line rule that maintains a stable background against which Congress can legislate. And I think the reason the court took this case is because you have a circuit split. You have a sort of multi-factor balancing approach to this question from the Third Circuit, a multi-factor balancing approach from the Ninth Circuit in this case, right? Maybe it illustrates the problem with these multi-factoring balancing tests, that on similar facts, the Third Circuit and the Ninth Circuit came out to opposite results. And you have a bright line rule from the Seventh Circuit, which says we just look to where the creditor is. And the court clearly came to this wanting each side to propose it a potential bright line rule. I think there's very little chance the court will just approve the sort of multi-factor balancing test used by the Ninth Circuit. And look, Yegiazaryan counsel, they came loaded with not just one, but two different bright line tests. They said, look, you can accept our textual argument, in which case, because of the particular language of this statute, language that was interpreted by Justice Holmes in 1906 in the Chattanooga Foundry case, you just have to look to where the person injured is. That's it. They say, even if you don't buy that argument, and you're going to get into this sort of metaphysical question about where is an injury to an intangible asset suffered, that should always be where the owner of the asset is, right? Again, simple, bright line rules. To steal a line from Richard Epstein, simple rules for a complex world. The court has a lot of sympathy for that perspective. What was surprising about the argument, there are bright line rules that Smagin's counsel could have proposed, right? This is the Russian creditor. They could have come in and said, a judgment is a special type of property. If you're talking about injury to a judgment, that's always felt where the court that issued the judgment is. right? Hey, it's a California judgment. It's in California, right? Don't think too hard about this, right? This feels very California. Or they could have said, listeners out there who have taken or remember their civil procedure class will remember the old case of Harris v. Balk, which was a judgment enforcement case like this, although in a sort of different context, where the court had to figure out where is a judgment for purposes of basically seizing that judgment. And the court in the Harris case laid out a bright line rule, said the debt clings to the obligor, the debtor, and follows him wherever he goes. Now, who's the debtor here? Yegiazaryan. Yegiazaryan's in California. That's a rule under which Smagin wins, right? Because if you're talking about injury to the judgment, which is a debt, if that follows the debtor, Yegiazaryan, who's in California, well, that's a domestic application of the statute. But for some reason, Smagin's counsel really rejected that argument. They didn't stress it in their briefing. They sort of ran away from it at oral argument. And when particularly Justice Kagan and Justice Kavanaugh pressed Smagin's counsel, can you sort of give us a bright line rule? Is it enough just to have the judgment, just to have a California judgment? He said, no, right? There has to be some conduct in California. And then said, okay, well, is just conduct enough? If somebody did a bad thing in California, is that enough to say this is domestic application statute? And Smagin's counsel said, no, that's not enough. Conduct matters, but we still have to look at all of these other factors, which in his defense, the Ninth Circuit approach, that's the Third Circuit approach. But the court was clearly dissatisfied with this. And part of what's going on is that I think the members of the court are aware that they are not experts in this area of law, right? And there were a lot of questions sort of asking the lawyers to explain to them what's the nature of the arbitral award? What's the relationship between the arbitral award and the judgment? Are they separate property rights? And so I think in cases where the court is sort of conscious of its own lack of expertise, they're going to be even less likely to adopt a sort of woolly, complicated, multi-factor balancing test. And so what's unsurprising, the court was really pushing for a bright line rule. What was surprising was that Smagin's counsel didn't really have one to offer. And I think that may place them at a disadvantage versus Yegiazaryan's counsel, which came in with not one, but two bright line rules. Regardless of whether you take their first argument or their second argument, the textualist argument or the sort of conflict of laws argument, they say that either leads to a bright line rule.
All right. I think that tees us up perfectly to talk about if you have any sense based on the legal arguments presented or the justices' questions or reactions, do you have any sense of how this decision will end up shaking out?
Yeah, I mean, with all the usual disclaimers about, you should never predict outcomes based on oral arguments. Look, this is a Supreme Court podcast, so I'll just go ahead and speculate. I think the court was more drawn to Yegiazaryan's textualist argument than you might have expected just looking at the briefs, right? The court didn't really press Yegiazaryan's counsel on that. He took a few questions about, look, is this distinction person injured in their business or property really so different from an injury to business or property? They were able to hold up that Justice Holmes opinion from 1906 and brandish it about. And I don't know that anybody gave the court a compelling reason to reject that. Right, to walk back from what is an applicable precedent of this court, even if it's almost 120 years old. It is a clear decision. It's a narrow decision. Right? I mentioned before that the court seems conscious of its own lack of expertise here. I think they're aware that issuing a really broad holding about the situs of intangible assets generally could mess up a whole bunch of areas of different law they haven't thought about. So resolving this question based on the particular statutory language of the RICO statute, in 1964C. It's a bright line rule. It's clear. It's narrow. It's simple. It's not going to affect a lot of other areas of doctrine. And I also think it sort of, it vibes with this court's particular approach to textual analysis, which is to really kind of parse every word of the statute and to try really hard to give every word meaning, right? And you can see that sort of baked into what the court did in that previous case, RGR Novisco v. European Community. The court there said it's not enough for the presumption against extraterritoriality to be rebutted in some other part of the statute. We're going to look at this subsection of the statute and say, is there a clear indication of extraterritoriality? And if not, we're really going to parse the language of the statute, which is where the court concluded that the focus of this subsection of the statute was injury, right? You know, I think that's an approach to textual analysis that's very associated with Justice Alito, who asked some questions sort of suggesting that he was sympathetic to this approach. So I think the court might be drawn to Yegiazaryan's first argument, that textual argument. If the court decides to go to the sort of metaphysical, woolly conflict of laws question, where is an intangible asset? Like, where is a thing that has no location? I think that's harder to predict. The court could say, simple bright line rule, look to the person who owns the statute. Here, that's the creditor, right? The person who, quote unquote, owns the debt. That's the approach that's consistent with the first restatement of conflict of laws, which was this sort of majority approach to these questions at the time RICO was enacted. Straightforward, simple rule, doesn't open the floodgates of US courts to a bunch of these RICO-style claims. But you could also see the court say, it's a California judgment, right? Someone doesn't want to pay that, that offends the dignity of the California court. This feels like a situation where California has a strong interest in deciding the dispute. So, you know, those factors seem to point to California, you know, or the court could, even though Smagin's counsel kind of ran away from this argument, they could adopt that old Harris v. Balk rule and just say, look, the judgment is a debt, the debt clings to the obligor and follows him wherever he goes, which in this case happens to be in California. I tend to think, just based on the justices' questions, of those options, they might go for the first one, advocated by Yegiazaryan's counsel. There was this whole debate about sort of the uncontroversial notion that when you're interpreting a statute, you should do it against sort of the background of the common law principles that were extant when the statute was enacted. That would seem to point to, we should look to where the owner of the property is, the creditor. But I think that one's a lot harder to call. And, you know, my sense is in part because that's the more difficult question that will push the court back towards that textual argument made by Yegiazaryan's counsel.
So typically the next question that I ask, kind of following our format here, is if there are any implications of the potential decision going forward. But I think you touched on the court's proclivity for more narrow decisions. So if it ends up that way, you know, then I guess there wouldn't be that many far-ranging implications if I understood you correctly. So I guess in the case that I did understand you correctly, I guess we're kind of nearing the end of our episode here. So I invite any closing comments or kind of final takeaways that our listeners should have about the case.
Well, I mean, so you're right. If the court decides this narrowly, it might not have a bunch of implications other than, you know, to this particular statute in transnational cases, the RICO statute. I will take up your question, though, because I think, you know, there are a lot of implications of potentially of this case, if the court surprises me, and cases like this. And the court keeps taking these cases about transnational disputes. They keep taking cases about this particular question about extraterritorial application the court is hearing another case about extraterritorial application of the Lanham Act, the Abitron case, this term as well, right? So these questions are not going away. And for whatever reason, the court seems to have a taste for them, right? And sort of the most general implication of this case and cases like that, I sort of mentioned at the top of the podcast, right? What sorts of transnational disputes are going to be heard in US courts? And that's kind of a big question, right? In the sort of coming generation, is the US going to continue to be a major hub of transnational litigation? Are US courts going to sort of exert their potential influence to shape the way transnational disputes are resolved? And increasingly, every dispute, particularly every business dispute, is going to have a transnational element. Or are those cases going to be pushed away, giving other court systems an opportunity, which they've been seizing, to kind of fill up that space? That's the sort of big picture implication. I think the sort of mid-level implication is, how is this whole inquiry about US choice of law, extraterritorial application going to work, right? Because these questions don't just govern the statute. I mentioned to you, we had an earlier case, the Morrison case, about the security statutes. We've had cases, even only looking cases at the Supreme Court. We've had cases about human rights statutes, right? And particularly for transnational business cases, the number one thing that transnational business actors want is predictability. They might not even care so much about what the answer is. They just want to know what is the, they just want to know it ahead of time. And so I think the way the court decides this case and the way it decides cases like this will kind of tell us, look, is this an area of the law that's going to settle into a predictable pattern? Or is this sort of disruption that took place after the Morrison decision going to continue on for another 13, 15, 20, 25 years? And maybe the narrowest implication, which is still really important, is really about enforcing judgments and awards. Is the US going to continue to be a sort of place you go to get your judgments and awards satisfied, a sort of clearinghouse? The court's been comfortable with that in the past, right? There's a previous opinion involving bond creditors of Argentina called NML v. Argentina, again, Justice Scalia writing, where he expressed some comfort with, you want to find out where your debtor's assets are, come to the US, use our discovery system. Nothing about that offends us. As I mentioned earlier, RICO is really strong medicine, both in that it gives treble damages and it spreads that liability around here. This case has the possibility to open up this sort of RICO strategy for creditors all over the world. That could produce a real influx of people seeking this relief into US courts. And I'm not sure that would be a good thing. You asked me for some closing comments. I guess my two closing thoughts on this, one is about context and one is about text. Let's talk about the context here. I've given you the facts of the case. I think it's really tempting to look at this case and say, why are they doing all this? Why are they bringing this RICO action? Why did Smagin's lawyers come up with this novel legal strategy? Well, they just want Yegiazaryan to pay them. But I don't think that's what's going on here, in part because Smagin can't get a $100 million judgment enforced in California. He probably can't get a $300 million judgment enforced in California. It's just, a piece of paper to put up on your wall with a bigger number on it. So this isn't really a case about enforcing a judgment in California. It's not really a case about getting money out of a debtor who lives in California. What's really going on in this case? This is really a case about spreading this liability to this Monaco-based bank. That's why I said at the top of the podcast, it's actually important that this case is not just Yegiazaryan v. Smagin, it's also CMB Monaco, the bank, versus Smagin. Because it's actually kind of hard to collect a big judgment against an individual. Individuals can move around, they can hide their assets, they can transfer them. It's a lot harder for a multinational financial institution to move around or to hide assets. And so I think Smagin wants very badly to convert this from a judgment, a $100 million judgment against Yegiazaryan, to a $300 million judgment against CMB Monaco, right? Now, I think when you start to realize that that's what's going on in this case, the case looks really different. It's not really a case about a Russian creditor versus a Russian debtor who lives in California, who has a California judgment against him, who allegedly did some bad things in California. At its heart, this RICO action is really about a Russian creditor and a Monaco bank who is alleged to have accepted a deposit from a Liechtenstein trust. And then the argument that a US court should come in and slap a mammoth treble damages award on this bank seems a lot weaker. And not only do I think that's the context for this case, there were some questions during oral argument, particularly from Justice Barrett, that suggest that the court also has a sense that that's what's really going on here. So that's a point about context. My last point is about text, and we've talked about this a lot. I tend to think that Yegiazaryan's argument about the particular text of the statute is compelling. I think it fits this court's approach to textual analysis. And as we talked about, I think it saves the court from issuing a sort of broad holding, trying to figure out the situs of intangible assets, which historically is a mode of analysis that's caused a lot of confusion, a lot of disruption, a lot of disagreements amongst the court. And if the court were to speak broadly for that question, think about all the intangible assets that are out there, right? Bank accounts, intangible assets, vast majority of securities, uncertificated assets, domain names, intangible assets. Your right to post to your Instagram account with 1 million followers, intangible assets. If the court were to try to speak broadly to that issue, it's going to create a lot more confusion than it solves. So I think the textual argument is compelling. Again, I shouldn't make predictions, but here we go. I think it's going to be compelling to the court too.
All right, Professor Simowitz, thank you very much for joining us today and breaking down this case, which who would have ever thought it was this soap opera is not quite the right word, but you could write like a little bit of a TV show about this. This is dramatic and thought-provoking. I like it.
You and me, Justin. I mean, if we get tired of of our day jobs, screenwriting.
Right. Yeah. All right. Thank you very much for joining us.
Thanks, Justin. Have a great day and a great weekend.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.